I agree with everybody. If the Fourth Amendment was at issue here, then I wouldn't have an argument.
So let's call the cases. Let's do. I'll call them together. State versus Silva, 25 CVV 648. State versus Tanius, 25 CVV 645. Let's just have counsel state their appearances. First, Mr. Christian.
Good morning, Your Honor. Matthew Christian for the Las Vegas Metropolitan Police Department.
All right, welcome and good morning. Mr.
Morning.
Stubbs.
Stephen Stubbs for the defendants, and I would point out, Your Honor, that I usually use my phone for electronic reference of the pleadings. I'm going blind today because I'm doing the Zoom instead with my phone. So I just wanted to point that out.
No problem. Just so everyone's aware, I appreciate the pleadings and the research being done. As a limited jurisdiction judge, we don't get a lot of these, and it's refreshing to see. And I note that both counsel referenced the cases that I was talking about, and I forgot the names of them last time.
Ren and Gamma.
Yeah, Alejandre, and then Ren and Gamma that overruled Alejandre, and I recall being in front of several judges doing Fourth Amendment motions when those two cases modified the would to the could test. So anyway, it's I've read everything, both of you, and I do appreciate the good work on the pleadings. Let's. Is there anything new or anything you need to just highlight and be brief, please? We'll start with Mr. Stubbs. You've got the you're the movement.
Yes, I just wanted to highlight that this is not and never has been a Fourth Amendment motion. We are not suppressing anything, and the facts of these cases are so different from Ren and Gamma. Ren itself states that equal protection is a separate thing that they were not dealing with the Ren case. They recognize that there is equal protection, and then there's the Fourth Amendment, and they of course found on the Fourth Amendment grounds to change the test to where the could test. Gamma actually analyzed Ren, and the main analysis was whether the Nevada Constitution gives more protections to defendants than the U.S. Constitution, and the Nevada Supreme Court specifically addressed that and said, no, it does not. We are going to follow Ren. And so I agree with everybody. If the Fourth Amendment was at issue here, then I wouldn't have an argument. But this is not a Fourth Amendment case. This is a case with actually a much higher standard. It's an equal protection case and a First Amendment case. And the part that we are fighting over is whether this officer regularly or even has ever in the past written a speeding citation for someone going 5 miles over the speed limit in the Tanius case. If he has, I have no equal protection argument because he was treated the same. You can only have equal protection if someone is treated differently. And so I need to know if I'm wasting my time with this argument. And they can simply ask the officer. I mean, this officer should know that's not if it is a normal thing, he should be able to come up with it. And if it's not a normal thing and it's happened in the past, he should remember. So this isn't a difficult thing to do if they simply ask the officer. And I need to know if there is, in fact, equal protection in the Tanius case. And I believe Metro has acquiesced that in these cases, the other subpoenaed items, the CAD, the report on the radar gun, that they are not going to charge the fee. And so I certainly agree with that. But thank you, Your Honor.
And let me just let me just ask a question. I mean, I get why the would and could and Alejandre and Ren and and gamma are being argued because we can argue by analogy, right? But no, I mean, it's not a Fourth Amendment case per se, but can't we say, okay, look, if that officer could pull you over, he could conceivably pull you over for any violation. And I think, I'm not going to steal Mr. Christian's thunder. He's very adept at this, but I think that's what Mr. Christian is saying. Mr. Christian, am I off base?
No, I think you're definitely on base, Your Honor. I think the point that I'm not really seeing here is what difference it makes what the basis for the pretext is. It doesn't matter if there could be a pretextual reason, but what the courts are telling us is that it just doesn't matter. So I just read the reply. It just came this morning. I read the motion. Nowhere in here does it explain how this somehow translates into a defense to a civil traffic infraction. So, it's not even a criminal case. We're talking about a civil traffic infraction. But even if it were a criminal case, there's nothing in these papers that explains how it's a defense. It's the exact opposite. This is not a defense as far as I can tell. And then I think my other point, Your Honor, is that even if the court were inclined to delve into this as some kind of defense, it would be very burdensome to try to compile records like this. I mean, we would want to be able to show, you'd have to go back and look at every traffic stop that this officer ever did, not just tickets that he wrote, but not just 5 miles an hour, but any tickets, if you really wanted to do an inquiry into it. So I don't think it's relevant, but if it were, it's very burdensome.
Yeah, and it's a point well taken in your moving papers, Mr. Christian, that and I see it, as doing as much traffic as we do in, Justice Court. Some are handwritten, some are written. I mean, there's a number of ways that these tickets can be issued, and I don't know that. Certainly, we have trial coming up, I think, in front of Judge Mills. Again, I'm going to reiterate from last week, I'm not doing this civil traffic trial, but I don't know how, from a practical standpoint, Metro would be able to if I was to grant the second part of the request, how you'd be able to collect all that. I mean, this officer's been an officer for quite some time. It's not like he, took the oath last week and wrote the first ticket here, right? So, no, I certainly appreciate that the CAD is going to be produced at no cost, and that Metro concedes that. I was going to order that anyway, but I really do think we're overbroad here with the second request. Oh, hold on, counsel. It's just incredibly overbroad because we're losing sight. This is a nice intellectual exercise, but we're losing sight of the issue. The issue is he going by the civil standard 5 miles an hour over the speed limit or not? Equal protection, really, I don't see that it necessarily applies. It is, I agree with Mr. Christian, it's not a defense, right? I mean, if I pull over only green cars as an officer, going 5 over, you're still going 5 over under the statute. And that's the point I think Mr. Christian is making. So I'm gonna rule that
Your Honor,
the CAD is going to be produced at no cost.
I need to reply, please.
Okay.
Your Honor, green cars is not in the Nevada Constitution, Article 1, Section, I believe, 24. Creed is, belief is, association based on belief is. Multiple courts, federal and the Nevada Supreme Court, have found these associations based on common creed or common beliefs to be protected under the First Amendment. I would have no case if it was green cars. I would have no case if it's anything other than what it is in Article 1, I believe Section 24, I wish I had my reference here, but I'm on the Zoom call on my phone, of the Nevada Constitution. Creed, that is the connection. And we can have a defense that they are not allowed to treat people of a different creed differently. And if he has not, if this officer has not pulled over anybody else for going 5 miles or less under the speed limit, then they are treated differently. And then there is ample evidence here that the reason that they had the pretextual stop was because they were members of the Mongols Motorcycle Club. That I will have no problem proving that in court. But you can't say green cars and you, this isn't a situation to where they had information or some kind of a suspicion, reasonable or not, that they were even engaging in illegal activities like you have in Wren and you have in Gamma. This is a group of people coming to Moapa Valley for a barbecue. They came for a barbecue. They met with their friend and they left, and they were targeted and treated differently because of their beliefs, because of their shared beliefs and the reasons why they're members of the Mongols Motorcycle Club, and that First Amendment is protected. Wren even states that the equal protection is separate and has to be protected. So this isn't green cars. This isn't white hair. This isn't even they thought they were committing any crimes. This was they associate with each other, and we don't want them in Moapa Valley, so therefore we are going to punish them. So there is a much larger connection here, and I would ask the person to consider that.
It sounds like that you're trying to make this freedom of association defense for a speeding violation, and frankly, I don't know that that's going to fly in front of Judge Mills. I think it's a tenuous defense. It also sounds like you're conceding that they were speeding, which is the issue.
I'm not.
Well, I mean, you don't have to. But you understand my point. You've made your record. You're very adept at this, Mr. Stubbs. You know you have relief as to your second request on the all of his citations that he's ever written. I think it's overbroad, and I'm going to deny it. Also,
Your Honor, that's
remember,
not what it was.
we do have. Hold on, Mr. Stubbs. I'm trying to make a record. Hold on. I'm trying to make a record as cleanly as I can, so you can do what you have to do should you decide to do it. 484A 7041 sub 3B says that the court may admit evidence if the court determines that the evidence has probative value to a fact at issue in this case. And that's why I'm making my ruling as I have. And so that's my ruling. And if you need to do what I assume you're going to do, you have time to do it before the civil trial, which I believe you said was the 17th. I don't even know because I'm doing these pretrial modes.
The 20th.
The 20th. So you have, ample time if you have to get the ruling up the chain here, so to speak. But both of you, thank you very much for your briefs, and thank you for your appearance here. I do have another hearing I got to call for Mr. Mills.
No,
Your Honor, I'd just like to put one more thing on the record, please.
I called it. Yeah. That ruling, Mr. Stubbs and Mr. Christian, that ruling is for both cases because I called both Silva and Tenius at the same time. So, and he's asking for the same thing in both. So, it applies in.
I'm not asking for the same thing in both, Your Honor. Your Honor?
Yeah, I'm listening.
Okay, with the Silva case, we asked for things that they acquiesced in their brief that they have no problem with. It's the radar readings. Evidently, there was radar, and there's radar readings for that day. And so we're asking for the radar readings of the gun that was identified for that day.
It said CAD in the Tenius, and every ticket that the officer's written in Tenius And in
No,
Silva,
no,
it
that's not
says
what it says,
CAD,
Your Honor.
and it says CAD and radar in Silva. Mr. Christian, do you have a position on the second issue in Silva? That is the radar data from this one gun for that day.
The radar data escaped me. I thought we were just talking about CAD. But I mean, the radar data in this case, if whatever would exist, I would concede is relevant.
Okay, and
I
that's
know that is.
I'm yeah.
And Your Honor, I think there's a
I-
misunderstanding here. I did not ask for every ticket this officer ever did. Every ticket where he wrote a ticket for going 5
over
miles
or
or less
not.
on a
Yeah,
speed.
I
Okay,
agree.
all right. As long as
Yeah.
that's on the record. Thank you.
That's what I'm ruling. Now, Mr. Mitchell in Silva has said you may have the radar from this radar gun for that date. He's conceded that issue.
Thank you.
Okay, now, and that frankly is relevant to the issue of whether there was a violation of the of speed. So, okay, very good. Thank you both. I appreciate your appearance.
Thank you, Your Honor.
Thank you. Okay, Moapa, are we ready on the